something there to facilitate what I'm not.
Number 4, the ordinance requires 50-foot right-of-way, 24-foot cartway. I think you already have that. I'm inclined personally not to grant it because I don't think
There's also that secondary access from Washington Road, and it's only 15 feet wide, so it doesn't need the 24-foot cart access, cartway
Can
access.
we, that's not going to be a primary access. It probably was required as part of the ordinance.
Right.
The secondary access.
I've seen people grant that before, so,
Yeah.
for emergency access.
Yeah, we would probably grant that as a secondary access. I don't see an issue.
So they'd be waived for the secondary?
So number 4 is going to be waived for the secondary.
And we think they have it already, but we're going to, hopefully you guys will fill us back in as to that cartway with, even if you can come up with, I think Kelsey already testified, the 2 vehicles can pass each other. That's really our primary concern, is access to the site.
Yeah. If the only concern was the secondary access, I don't really think that's going to be an issue. Number 5, the ordinance requires intersection with a public street, provides site distances conforming to PennDOT's standards. So Laurel Martin has initiated the permitting process for your HOP for Bigger Road, is that correct?
I'm sorry.
The HOP for Bigger Road?
Yes, we're in the process.
So we have to wait for you to permit then?
I think that this isn't really dealing with permits, it's dealing with site standards, site distance. Required and available site distances for each driveway, each direction have not been provided.
Okay, let me ask Mr. Brown, does the driveway on Washington Road meet the site distance requirements?
I don't know.
Okay, so we can't really do anything with that until we know. So we're just going to wait for your response on that.
Okay.
Okay. Number 6, as I've said before, I'm not willing to grant private drive status.
No.
Mr. Geiser?
Absolutely not.
Okay. Number 7, the ordinance requires the depths of the lots not to be greater than 2.5 times the width. We're going to need that information on what
Sure.
it exactly is. I don't think the board is necessarily adverse to granting something because of the nature of the site. But we need more information.
So we're going to wait on number 7.
Yeah.
Okay.
So you just went the actual proportions?
Exactly. Number 8, I think we all agreed to waive that.
Yeah, that's waived.
Yeah. And number 9, water service, what did we decide on that? What's that number 9?
So that makes two motions. Let's see.
Yeah. There is no public water out there. So,
I think they testified the lack of use of water on the site, lack of need for it.
We're going to waive that.
we'll waive that. Number 10, sanitary sewer service for the proposed subdivision. I think that ties in with the planning module.
Right.
We're going to have to consult with the engineer more on that. And planning module, we definitely will not waive. Anything that you want to request as far as actual facilities, you can make a request. But the planning module, we will not waive. Number 11,
We'll keep it at.
curb access. Ordinance requires defined ingress and egress points. I think Mr. Brown was going to do a little more research on that, come up with some sort of ideas on the stormwater management for the driveway. Is that correct?
Right. I mean, well, there's definitely, we can come up with something without a curved access, but what we put together may change, or probably will change, whether that is curved.
If it's paved or gravel.
I mean, if it's, well, you've already said you won't waive the paving,
Yeah,
so,
we won't waive.
Right.
you're saying it must be paved, so this is the second point of, well, if it's paved, does it have to be curved?
And again, I think our concern is more what you address in terms of stormwater management, whatever's the best practice for that situation, that's what the board's gonna look at.
Okay.
So that's, we need more information.
Sure.
Okay. Number 12, I think we all agree that we do not want you grading out 50 feet on the side of the drive because of these stormwater management issues. So if you could do the 24-foot width, which I think you're almost there, and then possibly a 6 or 8 foot wide seating of some type on the sides. Address that.
Address that so we can't have any over, we're close out there.
And that was it.
Oh, then, we submitted a response letter to Len Smith on November 29th, and are we going to get a letter back from Len Smith that addresses the comments and revisions that we've already made to the plan that further addresses this discussion tonight?
I think, my opinion is we've done that tonight on the record. If you want, obviously,
We actually submitted a letter in response. We've received no comments back from that.
right, I understand that, and that's not part of the record, and the documents have been submitted, but I think Dan's testified tonight, we've gone through each waiver request. Hopefully we put it all on the table. He's here now, if you have any specific questions. I've tried to have him address each waiver request as they've come up. I don't know what more we have in writing. Now it's in the board's province, not so much the engineers, in terms of the engineers provided advice as to what he thinks as to whether it may be waivable. Is there something more specific you want, Sean? I mean,
Well, there were 160-some comments, and we provided a response letter.
not on the waivers, on the comments.
Right,
Okay.
and we submitted a revised plan. We haven't received any response as to whether or not certain comments were addressed or not addressed.
Okay, no, that's different. We can, that's up to the board whether you want to engage your engineer to continue to do that. It may make sense. I'm not sure. Those weren't part of the proceedings this evening.
No, they're in the record, but
Understood. I thought we talked about the waivers.
I guess my question to you is, you seem to be making the argument that the annual fees that Laurel Mott Midstream was paying to the township should cover the engineering review costs. They haven't made that payment this year.
well, they made a $100,000 payment last year.
Okay, well, they haven't made that payment this year
Okay.
that they're required to make. In order for the board to move this forward, have the engineer review it, we can't keep spending taxpayers' dollars to continue to review this plan. What intentions do you have? We're willing to give Mr. Brown as much time as he needs to address some of those waiver requests. We can continue the meeting for a couple of weeks, a month, whatever you need, but we can't keep spending money, taxpayer dollars, to have this reviewed by the engineer. So what do you want to do? That's what I'm asking.
Well, I think the first $100,000 was to finalize all the comments for the land division, or the subdivision land development plan, so I think it's already been paid. So to the extent that this February 15th, 20 days ago, there wasn't money, that it dragged on for a year. So are you saying that unless there's a $50,000 payment, you won't make any more reviews?
No, actually, what I would like you to do is just submit whatever's required under the fee schedule, pay the application fees. If you want to, and Mr. Gallagher knows, he can object to that after the case. If you feel that they've already paid the fees, or these fees aren't applicable, or the engineer charged too much, you can go back and appeal that.
Well, I just would like to know, though, it's kind of, you haven't paid the application fees, but, going back to the last hearing, we've submitted 1, 2, 3, 4, 5 applications and have tried to pay application fees, even with the last application, and the township refuses to accept any application fees. So, it's kind of a funny situation, but that's, one thing about that settlement agreement is all those application fees have already been paid to you, so, that's our position.
Right, up and including this whole,
So let me ask you this. So you're saying that they're included in the settlement agreement?
$100,000 payment.
Okay, but what I'm saying to you is that your client has broken the settlement agreement. because there was nothing paid in February of 2011.
Okay.
Okay, so is it null and void?
No, what I'm saying is you can't have it both ways. Are you going to say that that covers the fees, or are you going to pay the
The
fees?
agreement says it covers the fees, Brian, and up until, I mean, you're supposed to.
Address that. I don't know how to answer something like that.
Well, it's written right there. You introduced that into evidence today where it says
Sean
includes
did.
all fees and permits and review.
Right, I haven't looked at it. 'Cause that's their opinion, that's what's done.
Well, you wrote it. You drafted it.
Well, actually, I think Mike Donaby and I, and maybe you, Raj, I don't even remember.
Yeah, I was involved, but
Yeah,
you-
but I'd have to go
because
back
you're
and look
language,
at it.
so, okay. Well, take some time, take a look at it, I guess, and get back to us.
What's your opinion?
I'd have to look at it, Brian.
I mean, not on that, but
Well, I think ultimately, from your initial issue you raised before we started this conversation, it's circular in nature, is you want the engineer to address your comments. Now, I wasn't at the meeting, Brian, where you've already had the engineer sit down with them, and I'm not sure if those comments were addressed or not at that meeting.
I believe that everything we went over tonight was already addressed.
Well, not so much tonight, the other issues.
Well, the whole thing, we went over everything, line item by line item. we went down to-
Maybe, Sean, what you guys can do, and maybe with Chris or Raj, go back and see what's left that you don't understand in terms of, that you need our engineer to address, then the board can decide.
Well, I mean, I'm just saying, there's, the comment letter process usually works. Here's our review, here's the comment letter, here's a response, here's a revised plan,
Right.
it goes back and forth. We took that next step and heard nothing.
Well, I think
We've received nothing.
my understanding was, and again, I don't have the dates at the top of my head, but after that last letter, that everybody sat down and met and went over that. There may not have been a written submission, but our engineer sat down with yours in response to that your comment letter and went and addressed it. I wasn't there, so I can't.
Well, I think one of the things, just for clarity, is it needs to be in writing, because it seems to be a moving target whenever we get some sort of a oral response, and here's what you need to do, and then it changes. So I think just for clarity, it should be,
Okay.
because we've taken that step, so I think.
Why don't, can you, I haven't looked at that in a while either. Can you go back and maybe this week, Raj, you and Sean or Chris can say what you need, is it everything you need left?
Yeah, I think it's proper and it's appropriate to put it on the record, everything, because we have, so.
A lot of these comments from the engineer we addressed tonight.
Right, that's what I'm saying.
A lot of the
maybe
major
gone.
ones we've already addressed, but there are some simple ones in here that haven't been addressed. And I suspect, Ms. Van Hoos, you're the engineer that did this comment letter on November 29th, 2010.
Yeah.
Some of the comments, for example, the ordinance requires buffer yards for developments. A landscaping plan has not been provided. Screening at the development site this is the response, will be via the existing topography, natural site vegetation, and forest. That's a little thin, I guess, is what I would say. Usually somebody comes in with some sort of a buffer, how they're going to buffer that site from adjoining properties. It may be through berming, it may be through landscaping, but it's really not addressed at all in what they've submitted. So as the engineer now, I guess you're the engineer taking care of this. Correct. It really hasn't been addressed.
I think what we're asking for is, instead of just saying that, putting it in writing, and so we
It's
have.
in writing.
You've got 2 court reporters now, so.
No, but what I'm saying is it's in writing. It's just that I think that
But
maybe.
you just made an opinion that that's kind of thin, and so we need to know a little bit more than that's kind of thin. What specifically is deficient?
I think your engineer already knows how to.
No, anything more specifics, the better, because I think there has been some confusion. For example, in our waiver, we would base our responses per the written response of your engineer. It would cite a specific piece of the ordinance. We would address that, and then we would refer to a different ordinance. I guess, it is kind of a moving target. It would be nice to have the specifics laid out. That way we don't run into this again and have, that really ordinance wasn't really what we were meaning. We were meaning this ordinance over here. Oh, okay. If we had this on writing, then there could be a systematic approach, and then we can address these. And if you have examples like that, then we know we have written examples from each of these items of what's in your mind. So we don't like that. What we're thinking, what's in our mind, is A, B, and C, and then we can specifically address that.
Well, does it make sense, though? I guess our engineer's already spoken to these issues. Your engineer's responded to the issues. Once again, I understand where you're at in terms of it'd be nice to know specifically what you want to do. But isn't it now the province of this board to weigh in on these issues like we just did with the waiver?
Well, let me tell you the problem, and you as an engineer understand the process of preliminary plans being approved and then final plans being approved on any type of a land development. We haven't had that. They haven't come in and made application for preliminary land development approval. And a lot of what you're saying would have been discussed during that process. All those issues would have been worked out, and then you would have come back in with your final plans. That's typically how it's done. But what they did is they tried to skip over the process and go right to final approval. And that's actually one of the comments that Lennon Smith addressed, is that you can't go to final approval of subdivision land development until you've been through the preliminary process. So a lot of what I'm hearing complained about is actually not having one engineer that I've seen from the beginning go through the process. But we're willing to do it, is what I'm saying. But that's part of the preliminary process.
Well, and I think too, Brian, a lot of the things the engineers pointed out to this board, again, is somewhat discretionary by the board as to what you want to do. So the engineer responding back as to what the landscaping plan is going to look like may put you back in the same seats next time and say, okay, he's weighed in, what are you guys going to do about it? I think we made some progress going through these tonight, and it may be worth, I know this late hour, we're not going through them now, but to the extent that both engineers have already weighed in, it's, again, this board is going to decide how to address each and every item.
Yeah, and I think that a lot of this letter from November 29th from Ms. Andrews was the ordinance requires wetland identification. And the response is in progress. No wetlands are expected to be found. I think you could just simply go through a lot of these comments and update them. Because a lot of what's on here is in progress. I mean, that's a lot of, look, I mean, just on this one page where I've got non-compliance on almost every issue, the response is the traffic circulation plan is in the process of being completed on every one of them. So I think it's just a matter of you sitting down, going through them, and probably, months later, you could probably just address most of these things that have come up. And in addition to the ones we talked about tonight, I would think you're going to be 99% complete with what you have here.
And then, Raj, in terms of having a writing, it may make sense at the end of that, if in fact the board ultimately approves the land development subdivision application, a letter can be generated saying that this is what we've agreed to. We've waived item 1, item 2 you're going to do this, item 3 we're going to do this, so that we have the final playbook as to what that looks like. I mean, I'm not denying you the engineer, I just don't know if it would be beneficial. He's going to say the same things that he said.
Yeah, I mean, are any of the board members engineers?
Well, we're relying on the response that we got from Ms. Van Hoos. And what I'm saying is a lot of...
Don't you rely on the response of your engineer?
Well, what I'm saying is a lot of her responses are basically that it's in the process of being completed.
Not all my responses.
Okay, how about
are
this?
like that.
How about if we update, as you suggest, can we get a written response on the updated letter?
Yeah, I think if Kelsey comes in and answers a lot of those questions, then we can give something substantive to our engineer to say, does this meet your approval? Other than that, like landscaping, I just picked that one out, Rod. He's not going to tell you what it is. I think this board's going to tell you. And they can't do that without a public session. So, but yeah, if you update and address all those issues, I think at the next hearing, hopefully we'll get it to our engineer to say yes or no, Brian, if they've met that standard. Whatever's left for the board's discretion, they can just knock out at that time. If that's
We've
okay.
looked at this.
Yes.
I mean,
He helped compile it.
we've covered almost all the big items tonight with the
Yeah, it's up
waivers.
to you guys. I don't care.
I think, I didn't see anything else that was a big issue in here for compliance. I think we covered all the big ones. So, I guess,
Quickly, yeah, I'm not sure
what
if
do you, how much time do you need to go back through these and update the status on them?
I guess what is the exact course? Do we like Ross suggested, would you I guess we don't want to work with a moving target anymore. And it seems like there's been a gap in, I wouldn't say communication, but a gap in expectations here. And as you see, we bring forth this waiver, we think it's pretty cut and dry, and you guys are like, no, no, no. Well, if we just keep this in writing, maybe we can move this forward a little more smoothly. And so what Raj suggested with, okay, we can go and based on this meeting and based on some other things, update some of our comments. And then could we expect a written response? Is that?
With some precision.
How long would it take for you
No,
To
update.
to update?
to update these.
What do you think, a week? Is that enough?
I mean, what time frame you think, in days, weeks?
That's up to you.
It's up to you. It's
And
your
you
call.
have
Well, we
to,
want sufficient time
you have
Yeah, I
to
mean,
request
we-
that we
prior
can.
to the next hearing that we can digest what
That
the
would be a
response
month.
is.
You can.
Right, that's a good point. Is during our next, are we going to just address these comments, or do you want a stormwater management
Well,
plan?
let me give you an example. This whole page is talking about the traffic circulation plan. I don't know, from our engineer's point of view, what is required for a traffic circulation plan.
It's pretty, I mean, it spells it out. There's locations of ingress and egress, access provision for parking and loading, site distance, which was another thing needs to be identified. But it's, a traffic circulation plan is provided.
Is there any problem with Mr. Brown contacting you on any ordinance questions if he needs to? Okay, why don't we do that?
No.
Go
Well, can
through-
we do, but what we want is contacting via letter.
Well, we can do that, but as he's going through these items, he can call and say, what exactly do you want as far as
I-
traffic circulation?
Personally, I prefer everything be done by email because
Written letters.
written letter is best. Plus, he is acting in the interests of Williams, but he is still under contract with us. He's not a Williams employee and can't speak on our behalf and make decisions on our behalf.
Okay, well, let me tell you, the only problem with that is you know how many times you're going to go back and forth with letters. So that's fine if that's what you want to do.
Maybe not. Maybe if we, we don't know yet. That's kind of the thing we want to define.
Okay.
And if we come back, and that's why the hard time with the time frame is trying to figure out the scope of what you're expecting. When I say revised comments, I think in my mind, we would revise, maybe narrow down those comments, maybe address them in a little more specifically based in light of what we've talked about. And then that would help us narrow down our plans, and then when we start getting into more of the...
Well, let me just ask Mr. Larkin, I know he's done a lot of these. A typical time frame from the time somebody makes application, preliminary application for subdivision land development, till they're done, what is typically does it take to get the whole process?
Until they get approval?
Till they get approval. I mean, I'm just trying to give you an idea. Not that I'm applying it to you because you're already well within the process. I'm just saying to give a perspective maybe on how long it typically.
I guess I don't understand your...
If somebody came in cold and made application for small commercial development, and they had to
Do
go through.
preliminary and then final, probably 6 months, up to 6 months.
So I just want to put that, not for you, I know you know obviously, but for your client, the typical time that it takes is 6-7 months. It's not something that you come in and do it. And I think
12 months.
I think the process would have been moved along a lot quicker if the preliminary was done, we got all the bugs worked out, and then they came in for the final. I think it would have been much, much better.
Sure, so do you want revised comments from
Well,
us then?
I think some of the comments are that we're giving the information, so obviously, if you have the information, we can answer some of those questions. They weren't objections, they were just information.
Right, something
gathering.
like road widths or whatever, the proportions of the lot, sure, we can provide those in our response back.
Right.
But,
A lot of it's just informational, we just need some more.
right, and I think that's where it goes back to writing, that way we don't have that expectation gap. I want to say, again,
Well,
not
a lot of these,
communication,
the expectation gap wasn't really there in terms of your responses will get it for you. And so if you have it, let's just knock it out and be done with it.
Yeah, I think a letter can be updated. I think the one thing that
Yeah.
we would ask is that instead of just regurgitating what the requirements are, you put the actual facility into context. For instance, don't recite that it needs sidewalks. It's just inapplicable. Things like that. Take a look and maybe consider it instead of just
Well,
spitting
he
it out.
That's
can't
not
do
my
that. The board can only
choice.
do that.
Make that kind of decision.
He can't review plans.
He can't make.
If the ordinance requires a sidewalk, I put
He has to stick
the
to
ordinance
just.
requires a
But I
sidewalk.
think the board's made that waiver, that's the process we're in.
So if we have, so you're asking for if we have this done to give it to him so he can review it. So if we have the traffic circulation plan done and we give it to him, he can't approve it.
Can you make recommendations?
Can you say?
Well, yeah, I'm just,
Well,
I'm not
I think-
let me just understand this
One at
process.
a time, guys.
Sorry.
Everybody's
One second
talking over
rule,
one
one second
another
rule.
again.
I'm just at a loss to understand the process. So instead of going back and forth with an actual engineer who interprets the ordinance, he's not qualified to interpret the ordinance, only you can do
No,
that.
That's incorrect.
He's not qualified to grant the waiver.
That's correct.
Well, we're not asking for waivers, but,
He cannot grant a deviation from the ordinance.
So
Even a minor.
if you submit
I
something,
agree with that, that's fine.
if you submit something and he writes back and says, this meets section 6.2 of the ordinance, we're okay with that because he's making that call for us, that's all. It's just the discretionary issues that'll come to the board.
Well, then what about like the provisions that, maybe not to go back and rehash, but I know there's a number of other places where you provide one set of regulations that would pertain to one type of development. Then on the other hand, taking the regulations that pertain to a second kind of development and saying that they both apply.
Well, I think what he's saying is the board, I think Dan testified, showing that the board would make that call as to whether they were going to grant the private lane status. If they did, then this section would apply. If they didn't, then the commercial section would apply.
And so we're just sitting there, we're trying to comply with this comment letter, and there's these two competing sets of comments that are apples and oranges, and we're left to guess which one the supervisors are going to say complies. Is that
Well,
correct?
I don't know if you're left to guess. You've requested one. The board will then make that call. And that's why I think there was that meeting with the engineers. And again, not being there, I suspect those things were talked about.
Yeah, but I mean, typically, there's a written response. So that's why we're asking for things to be in
I
writing.
understand.
And I guess there should be, again, there'd be a real life or a real-time feedback almost. And then we don't want it in a phone conversation day to day. But for example, we submit something and you're like, well, that doesn't work for us because this is our concern. It'd be nice to make, oh, well, then I could maybe come up, or us together collectively come up with a unique solution to address the primary concern, which was the basis of the ordinance. And so, not to lose the form over the substance. These ordinances are in there for a reason, correct? To protect the neighbor or stormwater issues. And then if there is some type of feedback, maybe what we had planned doesn't suffice, but we weren't, when you express your concern as, we're okay with the 25 feet. Our primary concern is having
Right.
two-way traffic. Oh, okay, then we can
Well,
address that a different way.
I understand, and I know you think it'd be nice if the engineer would have said that, but that's not his province. He's applying the ordinance down the line to you. You've asked for the waiver request, the board considered it, and in a lot of cases has granted it. So unfortunately, that's the cumbersome process, and this board doesn't meet that often. They can't sit aside on a Monday afternoon and do it. We have to do everything in a public setting like this. So that's really the problems with the timing of it.
Well, I noticed,
Okay?
for instance,
I think really, I've read through this while you've been talking. We've covered almost everything in your waiver request. There's almost nothing in here.
And the waiver requests are the specific addressing of all the issues.
Well, all the issues, but if you look at the issues, some of them are, the ordinance requires benchmarks, monuments, and iron pins. And the response is the four corners have monuments identified on the plan, and the monuments will be set in the field in the very near future. So you could actually read through this and probably, like I said, 90-some% of it, I mean, it may have already been done. I mean, these monuments may already
But
be set.
you said that you're fine with that, but we didn't know that until you said that right now.
Well, no, we're not fine with it. What he's saying is that,
You're almost compliant.
yeah,
Well, we don't even know if we're almost compliant, so you said that.
No, it's written here.
you wrote that we're going to do it, we're going to put these pins in. And so if you came forward, Chris, and said that's been done, then we would knock that off. That's all. We don't know until you tell us that those things that you say are in the process have been
You know,
completed.
like the wetlands thing, it says in progress, no wetlands are expected to be found. Well, all you really have to do is update it. Say, okay, there are no wetlands within so many feet, whatever the ordinance requires.
Okay.
Yeah, that's all.
Most of this doesn't require input from the engineer until you go through it and address some of the things that may have been completed. And then we went through some of the major waiver requests with you tonight. So I think you're pretty far along in what you need.
Yeah, I mean, again, all we'd like to do is go off the normal comment letter process where it's a whittling away, but, yeah.
Yeah.
There might be a better way than that. What if we came out to your site and looked at what you know, these issues, and we stood there and said, how about this? You know, well, I don't know. And we said, well, how about that? You know, this face-to-face letter writing stuff, and my God, we'll be 7 months getting this done. But if somebody actually went out there and stood there with you and said, why don't we look at this? Wouldn't that be a more efficient way of doing this? I mean, you know, we've been in this process for how long now? You say 12 months. I mean, everybody's got all these time frames. Why do we keep doing this? You know, you want to go to work and start your business. We want to get this done. We don't want to come here every month and do this. So this letter writing thing hasn't worked yet. Why are we going to do it again?
Well, we haven't really,
We haven't
we
received.
haven't really gone through.
Well, you got a book bigger than a phone book.
Right,
I mean,
well,
that's all letter writing.
I mean, to extent, I mean, we are already, we
Well, let's
have
come on
5
now.
different
Let's come
approvals.
out and look. And why don't we do it that way? Why don't we do it eyes on and we'll all stand together and make a plan? I think you're agreeable to that.
Well,
I don't know if you're allowed.
there are 160 comments. If we can get down to, here are the 5 comments that would resolve, I think that would be fine.
Okay.
But we would like to go through the normal comment review process that happens in every other municipality in Pennsylvania and just go back and forth with what comments
Well,
are
then-
satisfied
Well, then there's a good reason
township
for that.
engineers' satisfaction, which are not.
Well, I think, you know, we have a good start tonight. You're going to go back and make amends to, or amend that letter as to what's either been addressed tonight, Chris, or a lot of the questions that were in the process of being answered in November perhaps are answered now. So those will just be knocked off the list. And then, if need be, we'll have our engineer write you back and say, all those things have been met. He'll tell us that, and we're fine. If there's any sticking points, we'll address them. I mean, we can sit here all night and keep laboring the process, but I think that's,
Yeah, we just don't
we'll
have.
wait to get, you guys get back to us on updating that letter on what you've heard tonight. You know, the board didn't vote on it, but they've given you some guidance as to the waivers. Some of the issues, again, I think when you look back, as Brian said, there are pins, we'll put the pins in the property.
Right.
All right, if they're in there, then item 23.
Yeah, we haven't had an update since November 29. I don't.
Well, we haven't, that was a response. See, Brian, here's how it works. There's an initial comment letter, there's a response letter. There's the comment letter that comes from the engineer in response to that letter, there's a comment letter. We never got past, here's the initial one, here's our response. So we've been kind of stuck in la-la land waiting.
Well, I mean, the reason really is just for clarity. It's why you have minutes. You need to have some clarity, and so that's what we're asking for. We will. I'm sorry. Go ahead, Supervisor.
No, go ahead, Royce, I'm sorry.
No, I just wanted to say we will update what we can, so you've got the most current set of comments, and then just request that they be responded to in writing. And I think it's a great idea to come out and do it on
Are
site.
there
But
pins in the ground?
I can't answer
Are
that.
there pins in
Are
the
there-
ground? Monuments to mark your corners?
I don't know.
So if I came out and looked, oh, there they are, check done.
Yeah, right.
See how quick that is?
But we still need it in writing.
Yeah.
Well, you can do that after we check it out. I'm just saying,
Well, no,
it's
it's
just done.
you
You
guys.
can write all that all you want.
Yeah,
Guys,
no,
one at a time, fellas, please.
Ultimately,
Sorry.
that process, that letter or that testimony is going to be submitted at the public hearing. The board will just say, that's been met, that's been met. That's all. But I understand your position. You just want to make sure you comply with anything the board or the engineer deems you need to comply. So that's fair.
Okay.
The only question I have is, if we set another timetable for the meeting, okay, and you're going to give us this documentation. Engineers have a habit of half hour before the meeting to submit this information. I'd like to have some kind of a, what would you call it,
I don't
buffer
have that
zone or
habit.
something like that, so, pardon me? I understand.
I don't have that habit.
Okay, so that's my concern. I don't want to be rushed in the last minute with your information, you know, so
Are
I,
you okay with April's meeting time? Or do you want a special meeting in?
How long?
Well, how long do we think it's gonna take us?
Well, it depends. If we just do the comments, revise the comments
Yeah.
in like a week.
Updating it, and that's what I thought, updating the comments a week, and then if we can get a response in a week, that gives both parties, we share the same concern.
That's what I'm
Enough
saying.
time before the next hearing.
Yeah, are you okay with the April hearing date? That's all.
Yeah, if we can get it to you in a week, which I think we can, and we can get a response in a week, yeah.
I'm not concerned about the.
When's the next
It-
hearing? April 11th.
Do you want to close? Do you want a faster hearing, Raj? That was the only question.
No,
Okay.
we don't need a special hearing, I think that's.
okay.
Well,
So, but in a week, you're gonna have something to us, and then we're gonna have to respond within a week. Is that what we're
I
saying?
mean, we're going to try to meet those deadlines. I
Right,
know-
for example, the stormwater issue, I don't think we're going to have a solution that will satisfy you guys in a week.
Okay,
For
I
that.
don't want April 10th, you guys showing up and say, oh, here, we finally got it together.
Do your best. I mean,
No, I
Right,
think
but
we'll-
could we,
I think all we're looking for is just to whittle down the comments. There's
I think
160.
you've already seen it.
Okay,
Right, but we'd
yeah.
like to get that dialogue back and forth.
But
in writing.
here's what you need to do. We can't grant this. It's up to you. You have to request a time extension, Mr. Gallagher knows.
We'll do it on the record till the next hearing.
But what you can do is just leave it open-ended and contact us when you want to continue and advertise it. So if it ends up being a week after the next supervisors meeting or a week before, fine.
So we have to advertise.
well, we meet our advertising requirements. We'll shoot for the April meeting.
Yeah, I think if we can't meet that, if we can't get you updated comments, which is what is on the table within a week, we'll request something like
Okay. And if you do that within the week, Raj, that'll allow us to meet the advertising. We don't want to advertise and not have to do it.
I think 2 weeks would be good. Just in case we have
2 weeks for stormwater management?
No. I mean, all right, just to
We
get it
won't have a
revised.
complete stormwater management
Understand.
available in April.
Wait a second, we're not, I mean, we're just submitting
that. We're updating
a comment letter. We're not submitting all the plans.
Yeah, right.
Are we on board with that, now?
Okay, so you have to make a request.
We are requesting a additional waiver of the, or not waiver, we're tolling the statutory review period to the next supervisors meeting. And if we need more time, we'll submit a written request.
What-
In advance of advertising.
Okay. Is there a motion to grant Laurelmont Midstream's request to toll the application until the next regular supervisors meeting in April?
I'll make the motion.
Is there a second?
I'll second.
Mr. Lucchino?
Yes.
Mr. Dicer? Yes. My vote is yes. Motion passes. Okay. You have anything else? Yeah, I have to allow public comments during the hearing.
Can I ask one question?
Oh, yeah.
When can I come out?
Didn't we decide that after we whittle down the comments, we're gonna,
No, you said it was a great idea and stuff there.
it is a great idea, but again, after we whittle down the comments and we know what we're looking at. Doesn't that make sense? We know what we're planning to do, I would think.
Any further comments from the board?
No, let him, Russ, let him do what he has to do. This way, there's no complaints.
Okay,
Yeah.
okay, we are still in the hearing, so I'm going to permit public comments on the hearing issue only. Raise your hand, state your name for the record, please.
Well, first of all, I'd like Mr. Gallagher back out here, because my comment's actually going to be directed to him. But for the record, my name is Richard Ward. I am the chairman of the Robinson Township Planning Commission. Unfortunately, I was not at the hearing last month. However, I did get to listen to the recorded meeting. And I do have a couple of comments and concerns and issues with Mr. Gallagher in particular, sir. So I'm going to address you directly. You made a comment during last month's hearing, and I'm sure at this point you probably don't remember it, but you basically called my integrity into question, and I do take offense to it. Your comment had to do with the Planning Commission's recommendation for denial and the written response that I provided to the township supervisors. And your comment, without quoting you verbatim, basically you took issue with the fact that you thought I had more information than you thought was practical, given the situation. And I'm going to refer to a couple of quick things here. Obviously, it's on the record, you guys came in on November 29th for your original hearing. At that time, we all talked, and this was kind of muddy in the in last month's hearing. We agreed that you folks were going to go back with your engineers, the township engineer, work out the issues that had to be addressed, because the submittal that was given to us that night addressed, I think we talked about it tonight, 160 different comments. We spent 3 hours going through this with you line by line, which went against my better judgment, to be quite honest with you. Personally, I don't think that submittal should have even come to the board at that point. We had no time to review it. We had no time to get a response from the engineer. That was why we agreed, and you made the request to be able to get the engineers together without all the lawyers involved and address those issues. The understanding was that December 13th was going to be the continuation of that, with the understanding that that meeting happened and the Planning Commission was provided the updated information for our review. That never happened. Now, the December 13th meeting, we ended up, for lack of a quorum, the lack of a quorum came as partially a result of the fact that we had no information sent to us to review. Therefore, being that we were going into the holiday season, we did not have people for a quorum at that point because we had no need to meet. We had no information. So you went at that point on our regular December 20th meeting. You failed to show for that meeting. Now, as I understand, you did submit documentation for us to consider granting 12 waivers, which obviously has come out since then that we don't have the authority to grant the waiver. We can make a recommendation to the Board of Supervisors. We don't grant waivers. That information was provided to us at 7 o'clock when we walked in here on December 20th. In my answer to the supervisors, or the recommendation to the supervisors, I made reference to the notifications that you were given and your acknowledgement of those notifications. And your comment last month, like I said, questioned how I had that information. That information was sent to the entire Planning Commission when we were provided with that list of those 12 waiver requests. That was sent out at, I believe it was sent out at 11-something in the morning or 12-something in the afternoon on December 20th. That was part of the email chain. So it only took somebody to look at the email chain to see what time you got an email from the township, what time you responded to the township, and the township forwarded the email out to the Planning Commission with the information for us to consider. Now, of course, because that came out at 12:44 in the afternoon, and we are not full-time employees out here, I didn't even see that until after the meeting. The first I saw of your request was when we came in here and sat down. Had you shown up that night, we could have addressed those issues that night. You kind of put us in a position where we found out through council that the subdivision and land development could not be separated. We had to hear them both. Had you been here that night, I would have presented that to you and asked you at that point if you wanted to continue so that we could address those issues. You didn't give us that opportunity. So again, I take offense to the fact that you made that insinuation that I had inside information when all it took was following the email chain.
Well, I apologize. I wasn't insinuating anything about your integrity, and I apologize if it was construed that way.
Okay. I appreciate that. And I mean, for the record, the only reason the board made its decision was based on the information we had available to us. You know, there's been a lot of argument back and forth about who's playing on the up and up and who's not, and it was a lot of that went on in that meeting last month from what I listened to. Maybe it's time we all play on the up and up here, and hopefully you've gotten some of that here tonight, but I didn't get that feeling from you guys back in December.
Fair enough.
Okay? And thank you.
Any other public comments on the hearing issue? Mr. Gallagher, I want to thank you for your demeanor this evening, very professional. I want to thank you for that, sir.
Thank you very much.
If there's nothing else, on the hearing. Is there a motion to continue the hearing until the April supervisors meeting?
I'll make the
A
motion.
second?
I'll second it.
Mr. Lucchino?
Yes.
Mr. Dicer?
Yes.
My vote is yes. Hearing is continued. We have public comment. Gentlemen, if you want to go, that's fine. We have to continue our meeting for just a couple of minutes.
So, gentlemen,
Lady.
you look like you're sitting there like, well, dude.
How about me?
Thank you.
Okay, the board did have a workshop meeting scheduled this evening, but
We're canceled.
is there a motion to just have that after the April meeting?
I'll make that
A
motion.
second?
I'll second it.
Mr. Lucchino?
Aye.
Mr. Dyster? My vote is yes. And that'll be held after the April supervisors meeting.
You sure you want to push that till May?
Yeah, I never
You
thought
might
of
want to wait till May.
Are there any public comments? State your name for the record.
Okay. Since last summer, 2010, Environmental Integrity Project and Vermont Law School Environment Law Clinic have ongoing concerns about the Champion mining permit. This permit is currently in the PADEP being modified, and the public is still waiting for their public hearing, which is now over 18 months past due. In May 2010, PADEP cited violations on CPI land, including, quote, failure to design, construct, and maintain treatment facilities capable of collecting and conveying all discharges emanating from the coal refuse disposal area to treatment ponds number 6, outfall 001, end quote. Corrective actions are required. Did Robinson Township receive a copy of this violation documentation from PADP or CPI? No? Okay. And did Robinson Township receive a copy of the response from PADEP by CEC Champions Consultant?
That's the secretary.
Okay.
Did anybody in the office?
Anything?
Chris, did you receive any?
No, I can't.
Okay.
Just leave a copy of the letter.
Okay. A recent file review by the PADEP shows on October 29, 2010, an email from RPC consultant Joe Pezzi stating that Robinson Power Beach Hollow plant has met with the township and this is a quote, has met with the township and is proceeding to get the original conditional use permit modified. The township is working with Robinson Power to accomplish this, end quote. I have the emails that show that. This is what's in the DEP file. So this is in October of 2010 that Pezzi's telling the DEP that he came here and he met with the township and he's getting all these things. But I was at the January meeting in the Planning Commission, which was the pre-application meeting, where Raymond Bologna and Joe Pezzi attended, seeking information about the new project at the site of RPC. It is my understanding that this was the pre-application meeting and that they did not yet make application for anything in the township. And I asked the question, is this the case? I think I know the answer. Could you please tell me the status of any local applications, if any were submitted by RPC or Champion? And if I need to, I'll make a right to know request. Is that what you would prefer? I wasn't aware that the plant that Neil Matchett had spoken with Raymond Bologna, so,
There's been no application made for anything.
okay. Well, I'm just going to give you, so that the township has a copy of what's in the public file, these communications between DEP agents to Mr. Pezzi and their plans that it appears as though they're telling the state one thing, but coming into the township and doing something different. And my personal opinion, I've been down this road before with them, so I'm just going to submit this. And that's the end of my comment because it's really, really late.
Thank you. Is there any other public comments?
Take care.
If not, is there a motion to adjourn the meeting?
I'll make the
Is
motion.
there a second?